Okay. Now we will look at some of the ethics issues that relates to technology. First issue is about privacy, and this is basically, can say, this is one of the main issues with regards to technology. With technology, there will be concern with regards to privacy, specifically about data protection. Okay. First of all, it's about the cookies. Okay. Cookies are data from a website that is stored on a computer, which is then sent back to the website. So when you browse, when you browse a website, your browser will collect some data, will store some data on your computer, and then this will be used then to send it back to the website. So by using cookies, um, data will be captured with regards to your browsing behavior. Okay, so there will be some privacy concerns here. So with regard to data protection, because of exposure to your browsing data being captured by a lot of websites, then certain countries, especially in the European Union, enacted regulation which include the right to be forgotten. There is a law that allow internet users to have unwanted links removed from Google's search results. So generally, right to be forgotten is about allowing the users to request that their links, the links that they generate to their browsing habits, to be deleted, to be removed from search results. General Data Protection Regulation is a European Union law on data protection and data privacy, and have some very strong or rigid requirements to protect the privacy of consumers. And because of this very strong or rigid regulation, organizations that try to comply to the rule will incur a lot of cost. And there are cases when businesses from the US, for example, tried to conduct business with consumers coming from the EU. They tried to fulfill the requirements of the GDPR, but in the end, they decided to quit and to not enter into the EU consumers. Okay, they stick to the US and other places. Okay, because of compliance cost. United States lacks a comprehensive consumer data protection law as compared to the Europe. Children's Online Privacy Protection Act is a US law that directs the Federal Trade Commission to create and enforce regulations governing the online privacy of children. Okay, so there are specific acts that try to protect the privacy of children. Next, the issue of surveillance with regards to privacy. Okay, surveillance. Surveillance tools include cameras, beacons, biometric surveillance technology, facial recognitions, and these things, surveillance such as CCTVs in the buildings that capture primarily for the purpose of for security. However, because these cameras capture people's actions without their knowledge, and this information is sent to the cloud to some servers, now it actually invades the privacy. Okay, on one hand, it is used to for security, for theft detection, but now that data is available for use of other purposes. Okay, so therefore it invades the privacy issue. Many are concerned that recognition technology is not accurate enough, could lead to misidentification and major trust issues. So on the other hand, because some of these surveillance tools are not as strong, it's not up to the level of accuracy. When these technology are used to identify criminals, for example, but because of their level of accuracy, low level of accuracy, they might mistakenly catch someone through the surveillance machines. Those people who are not actually the criminals, but has some similarity in terms of their appearance, just because the low level of accuracy in the devices. Okay. And also, it is reported that there are facial recognition technology that suffers from racial bias, meaning that a lot of these technologies are developed by the white, by the Caucasian, and their data to train these technologies, they use Caucasian faces. But when it comes to recognizing a non-Caucasian, the non-whites, the machines will make more mistakes in identifying the people. Okay. So there will be some racial bias here. Critics call the technology as invasive. These technologies are implemented in the name of safety, like I said, but can put privacy security at risk. Next is the issue of employee privacy. Uh, the problem is with employee privacy. There are few legal protections. Legal protections are not enough. When employees work for an organization, they are monitored by their employees, primarily for the purpose of to manage productivity and protect resources. They want the manager the employers want to make sure that the employees are using their time effectively and using the resources of the organization effectively, and not waste them or not misuse those items. Therefore, a lot of employers find it necessary to monitor, to use the surveillance tools and so on, to monitor the emails that the employees send, to monitor the internet activity of the employees, to ensure that the employees are not using the company time and resources for personal use. Okay, so on one hand, the purpose is to ensure productivity and yeah, productivity of the employees. But on the other hand, to ensure productivity, they had to embed the privacy of the employee. Okay. So and because of the monitoring, it is generally agreed that employees have a right to monitor company email. Okay. But that is in argument. Okay. Some people would think that reading emails of employees is unethical. Okay. But on the other hand, employers would argue that they need to read emails because they are using the company email. Therefore, company email it should be used for official purposes, not for personal purposes. Therefore, there is no need for privacy, because they are doing it for the as representative of the company, which the company should be able to know. The next issue is with regards to intellectual property. Intellectual property is intangible ideas and creative materials. Okay, so intellectual property, if you something that you create, you design through your ideas, through you create a movie, you create something in writing, you create a design, you make a drawing of a design. So these things are intellectual property. They are intangible. You don't see it physically, but usually you have it in electronic form, and these things have value. Okay. And technology advancements are challenging the ownership of intellectual property. So among the examples of intellectual property includes copyright, trademark, and patents. Okay, so copyright protects original works, both published and unpublished, including music, literary, dramatic, and artistic works. Um, there is a Copyright Act that protects copyrighted materials on the internet. Then there are trademarks. Trademarks are protects words, phrases, symbols, and designs. There are issues where cyber squatters defraud businesses and consumers by using the trademark name of an organization to lure consumers into going into their phishing website. Okay, so for example, you have one company that has a trademark name. Some cyber squatters register for a website domain with a name similar to the trademark name of that particular company, and therefore people, when they search for the website for the company, they will mistakenly go to the cyber squatters domain, and then the cyber squatter may collect information from there. So those are some of the issues. Patent infringement is when an organization makes, uses, or sells a patented item without permission. Okay, so one company produces a design, for example, a design of a new product. So they to protect their product from being copied by their competitors, they file a patent. Okay, however, some companies uh, may develop or may build the item that has already been patented without permission. So it involves misappropriation of emerging technologies, um, uh, and therefore this is difficult to be proven in court, expensive to be brought to court, because it involves emerging technologies, which involve a lot of the things that are not in reality, but in, online, or in electronic form rather than physical form.